Hello, guys. Good evening. Thank you, guys, for joining me today. My name is Ifeoma Odunlami, immigration attorney from the Odunlami law firm. I'm uh, I'm going to wait for some people to join me, and then we'll get onto the topic I want to discuss. So, if you join me, please check in on the comment. Let me know you're here. Say hello, and we can get started. So, for those who do not know me, or for those who are joining me for the first time, my name is Ifeoma Odunlami. I'm an immigration attorney from the Odunlami law firm in New Jersey, but we serve clients in all 50 states. And today, the topic of this live will be the fee increase. So I had made several videos about it because maybe a few days ago, we were told by AILA, American Immigration Lawyers Association, that there's going to be a fee increase. We've been expecting this fee increase since last year, January 2023, when there was a proposed rule with regards to the fees, right? And so everything came down January 30th, which was 2 days ago. And so I had done a couple of videos and I got a chance to review the new rules, the new increase. And basically, guys, there's good news and bad news. So let me say hello to the people who are joining me and then we can get started. And before I continue, you guys don't forget to check my website, www.odunlamilaw.com. And we have a lot of free information. We have a newsletter, and you guys can subscribe to it and get more information because I really do a lot of work in preparing these newsletters for you guys. So it's yours for free. So take a look at it. And feel free to share this video with anybody that you think may need it. So yes, we talked about the fee increase. Now, USCIS says that they're self-funded and that basically they have to increase their fees because the increase will make them more efficient. They will hire more people, and the processes will be quicker for everyone. So will that be the case? I don't know. Let's see. But the good news, well, the bad news is that there's a fee increase which goes into effect April 1, 2024. But the good news is that it wasn't as bad as we thought it was going to be, because what we thought was based on the proposed rule last year, January. And what came out on April 30th was not as bad as we thought. So I guess it makes it feel like good news because it could have been worse. So guys, I'm going to share my screen so that we can go over the changes. And it's really important for you guys to pay attention and know where to get information. So the USCIS has a website. You want to be very familiar with it if you're representing yourself in doing this stuff, because there's so many changes that happen. And one of this is going to be this fee increase. It's different from it was before. Some of the forms are going to change as well. So you want to make sure that you're not sending the wrong forms, because if you send the wrong forms, it'll be returned. And if it's a form that is time sensitive, you could be barred. So basically, USCIS, I'm going to share my screen, but you're only going to be able to see it if you're on YouTube and Facebook, because I'm not able to share it on Instagram. So basically, to summarize, let me share my screen and then we can go through it real quick. Guys, if you, I'm going to say after this, maybe you guys can, if you can go on what you may call it, on YouTube or Facebook, so you can follow with this. Or if you can't get there right now, you can check it later. This information is on the website, the USCIS website. So basically, this, like I said, USCIS has not increased their fees since 2016. So they say that this fee increase is necessary. So primarily, the final fee rule, which, as I said, is going to go into effect April 1, 2024, is actually creating a lower fee for certain people for naturalization services and for adoption services. And so the good thing, this is one key thing, is that the final fee rule is actually given fee waivers to certain humanitarian applicants. So what that means is that if you have, if you're in a certain category, such as the T visa, the U visa, VAWA, and the like, your final adjustment of status, you can file to a fee waiver so that you don't have to pay the filing fees. So this is really, really, really great news. And it means that this new rule makes the fee exemption more available to more people. And a fee, you can apply for a fee waiver so that you don't have to pay the filing fees. So for instance, if you're filing a VAWA case, you can submit a fee waiver so that you don't have to pay the adjustment of status. If the case is denied, you can submit a fee waiver in connection with the VAWA to get the appeal waived. You can also get a 601 waiver waived, the filing fee waived in connection with the VAWA, or a work permit in connection with the VAWA. So this is really, really, really great. And it makes it available for SJIS cases as well, for special immigrant juvenile status. It makes it available for, like I said, T visas, U visas. This is all really great stuff. Now, the USCIS is offering $50 discount for those who choose to file online. So that's what they're going to be doing, and all that. So let's I think I talked about this. So let's go to the fee, the difference in the fee itself. And I'm only going to talk about the case type that we primarily do. So the I-90, which is the application to replace your permanent green card, if you lose it or if you want to replace it for some reason or the other, right now the fee is $455 if you're filing with paper filing. I'm just going to do paper filing because that's what we do primarily. Now, this NPRM basically means the Notice of Proposed Rulemaking, which was what was proposed in last year, 2023. So when you see NPRM, that's what that means. So the current fee is $455. What was proposed was $465, and yes, that's what they pretty much went with. But it's just a $10 increase, which is not terrible. Now, these are all employment type immigration filing fees, so I'm not going to go through those. Now, let's talk about the family petition, the I-130. The Form I-130 is currently $535, right? We thought, according to the proposed fee last year, they were going to increase it to $820, but finally they said no, it was going to go to $675. So it's $140 increase, but it is so much better than $820. So that's what I mean by, even though there's still an increase, it's not as bad as we thought. So honestly, I'm really glad, because if they're going to increase the fee and at least it's not going to be a crazy staggering amount, then it's not that bad. We're just only going to hope that USCIS will use this fee increase and actually make the process easier. I mean, that would be really, really great. And the same for the I-131, which is the application for travel document. That's a paper, that's the what allows you to travel while your case is being processed. It was $575 if you apply for it without an adjustment of status, because typically back in right now, if you apply with an adjustment of status, the employment authorization is free. The advanced parole, which is travel document, is free. But after April 1st, 2024, it's not going to be, that's not going to be free anymore. And if you apply for the I-131 on its own, it's right now it's $575, but it's going to go to $630, which is, I guess, was the same thing that they proposed. It's a $55 fee difference, which is not so terrible. Now, this is where some of the fees go up quite a bit. If you're applying for the Form I-212, which is permission to come into the United States after you've been deported, right now, the fee, filing fee is $930. But what they proposed last year was $1,395. So you'd be glad to know that they basically settled to $1,175, even though it's a $245 difference, but it's much better to pay $1,175 than $1,395. So there's also an increase with the appeal. When you have a USCIS determination and you want to appeal it, typically you use the form I-290B. And right now it's $675, but it's going to go up to $800, which was what they proposed last year. So they kind of kept to that. And then the form I-360 right now is $435. It's going to go to $515, which again is what they proposed. It's an $80 difference. Not crazy. So, that's not too bad. Now, the form I-485 adjustment of status with biometrics, right now we're paying $1,225 for it. Last year was proposed to be $1,540, but the final rule is going to have it be $1,440. It's still a significant increase, which is $215, but it could be worse. Now, for kids who are under the age of 14 in certain conditions, they actually, when they find the adjustment of status, they pay less. Right now, they're paying $750. They were proposing to pay $1,540. So you'd be glad to know that they basically kept it at $950, which is a 27% fee increase. And then the 601, which is the waiver, the forms for a waiver, currently is $930. It's going to go up April 1 to $1,050. So if you need to file, you might want to get filing, because even though these are not, the increase is not as horrible as we had thought, but it's still an increase, So 601A, which is the waiver for unlawful presence, it's $630 right now. It's going to go up to $795, which is still an increase, but not as bad as it could have been if the proposal of last year held. So the I-751, which is when you have a temporary green card and you're looking to get a permanent green card by removing the conditions on your green card, is currently $680. Come April 1, 2024, it's going to go to $750. And the I-765, which is a work permit, which when you apply for it on its own, it's $410. It's going to go up to $520. That's quite a hike, and I think that's okay. The naturalization, which is right now $725, actually went down to $710. And I think there's something else that they are saying with naturalization. If you can prove, and I think it's somewhere above, I noted it, if you can prove that you are, if you can prove that you are basically, let's see where it is. If you're within, I think it's $150 and $400 above the, within the poverty guidelines, you can actually pay just half of that. I'm going to go through that again, because I know that naturalization is being made cheaper. You can pay for half of, you can pay half the price. Okay, here it is, yeah. So if you're filing for naturalization and you show that your income is between 150 and 400% of the federal poverty guidelines, you can actually pay half of what it is currently. So you'll be paying $380. And this is all to encourage people to naturalize. So this is really great. Like I said, this is an election year, so take advantage of this and file your naturalization. So I think, is there anything else? I think that's pretty much all I have for this. So stop screen sharing. Okay. So I'm going to see if you guys have any questions. I'm going to answer some questions, but as you can see, the fee increase is going to take place. It's going to happen. There's a final rule on that. It takes place April 1st, 2024, and there's certain forms that are going to be to change. And basically, USCIS is saying that they're going to give you a period where you can use the old form and the new form, but you have to use the current filing fee, right? So between April 1 and June 3rd, 2024, they will accept old editions and accept new editions at the same time, but you have to use the filing fee, the correct filing fee as of April 1st. And so this is my advice to you guys. If you're filing paperwork, just before you submit it, you want to go to the USCIS website and make sure that you're using the right edition, okay? That's actually what you should do all the time, but more important now because there's going to be there's changes to the price, changes to the form, and several times there even changes to the address. So before you mail out a form, you want to make sure that you're using the right form. So let me look at the questions. Hi, Joy Beast, and Happy New Year. MK says, Dear Attorney, since you're dealing with successful VAWA cases, do all witness letters get verified by USCIS? I think you asked me this question yesterday and I answered it. MK, didn't I? Either by calling a home visit or have you had any VAWA cases with this issue? MK, what I said yesterday still holds today. USCIS reserves the right, and they have the right to go ask people who wrote affidavits or witness letters. They can call them, go visit them, and ask them questions regarding what they wrote. Yes, they can do that. Now, do they do that with all cases? I doubt it, but yes, they can do that if they want to. That's part of their investigations. So Hiram says, hello, do you deal with I-751 solo with no divorce when the spouse refuses to sign the forms? So Hiram, that's a really great question. So when you're filing your form I-751, which is when you're trying to remove the conditions on your temporary green card, you're supposed to file it with your spouse. That's called a joint filing. However, in certain situations, you have waivers which allow you to file it on your own. So there are 4 waivers, and you can decide which one is going to work for you. So there's the waiver of, divorce. If you guys are divorced, then you can go on your own. So if your green card is kind of getting ready to expire and your spouse is already telling you that they're not going to, join you to file it, and the relationship is pretty much dead, it's actually better for you to get a divorce so that you can do it on your own, because USCIS is going to need, for you to get a divorce waiver, USCIS is going to need a completed divorce. It's not going to be sufficient that you file the divorce. If at the time you call for the interview, you must have a divorce decree, otherwise you're not going to get your conditions removed. So I always tell people this: instead of begging and pleading with somebody who is basically intent on making sure you don't have your papers, file the divorce. If the relationship is going nowhere, file the divorce and be able to proceed on your own. It's empowering to know you can do it on your own. Now, if you have to do a divorce waiver, you still have to prove that it was a bona fide marriage, which means that you still have to prove that you entered into the marriage for bona fide reasons, for good faith reasons, to be with this person and not just for immigration benefits. Now, the second waiver is the waiver of extreme cruelty and physical battery. That's like the VAWA waiver, right? So if this person is treating you badly, is, trying to control you, and, abusing you emotionally, physically, psychologically, or whatever, you can file, go on your own, self-petition to remove the waivers. Self-petition to remove the conditions on your temporary green card without this person. Of course, like I said, you always have to prove that it's a bona fide marriage, and as well as that, you have to prove that there's been abuse in the relationship, right? So if you need help with that, call my office. We do a lot of this type of work, 973-993-1900. And then the third waiver is the waiver of death. I don't think that applies to you because your spouse is refusing. Clearly, the person is still alive. So that would apply for people whose spouse has passed away and clearly cannot join to remove the conditions. And the last waiver is extreme hardship. You have to show that if you were not allowed to stay in the United States, it will cost you extreme hardship. So here I'm sorry that you're dealing with this where your spouse refuses to sign the forms, but if you need assistance, call us. Let's see, applying for both EAD and parole, how much is for both? So Joe Ebison, I would have to look through this chart, but basically there's a cost for both of them. So if you go to the USCIS website, because I don't have time to do it right now, but if you go to the USCIS website, new immigration fees, you can see how much it's going to cost then in April 1st. Now, if it's now, the EAD is $410, and the advanced parole, I believe, is $575. I think that's what it is right now. How much is going to be then? You have to check. Okay, I think I mentioned. So it's $575 now, and EAD, which is employment authorization, is $410, and that's going to change. So you want to check on that. So Sasha 5 cents. This is a really great question. I'm going to read it out. You said, I did not file for my daughter when I filed for myself. She's now 24. Can my U.S. citizen husband still file for her? So Sasha, that depends. If you were married to your U.S. citizen husband before your daughter turned 18, then she is a stepchild and he can file for her. But I want you to know that it's going to take a long time because she's now under a preference because she's over the age of 21. All right. And so Akwaugo Ndudi says, my parents will be eligible to file for citizenship in January. Will it be quicker for me to file for my adult siblings or for my parents to file? So Akwago, you have to look at the visa bulletin. First of all, you need to know that the sibling filing is the longest in all the preference categories. So chances are it's going to be quicker for your parents to file. Now, if your sibling is single, it will be much quicker because they're going to be F1, which is, taking maybe 6, 7, 8 years, as opposed to F3, which is a married child of a U.S. citizen. That takes longer. So look at the visa bulletin and that should help you, all right? So Donovan says, I have a daughter in the US, she overstays her visa. Can you help her get a green card? Donovan, if I knew more about your daughter's situation, I would be able to tell you whether or not we can assist her. So call my office, 973-993-1900. Let's see if we can help, okay? All right, let me look at Instagram. Hi, Instagram people. Thank you for joining me. So let's see the questions you guys have. Hello. Inesi, hi. Hello, all of you. So let's see if I can grab a couple of questions here. And Instagram, honestly, I cannot wait for when I can also go on Instagram from my computer. That way I can read the questions better because it's so tiny, the print. I'm not seeing any questions on Instagram. Okay, Akugo, I answered your question already on. So I saw this question. So Sunshine says, if I file for my mom in another country, how much is that? Sunshine, it's the same price. If you file for your mother who's in another country, that's consular processing, right? So the I-130 is $535. Then you have to, when you go to NVC, there's a bunch of fees which total $445. And then, you have to do other things, before the interview. And if the interview is successful, you have to pay the Ellis fee, which is $220. And you want to check to make sure those have not changed. I know the Form I-130 is going to change, so you might want to file right away. Now, if your mom's in another country, that's how much it's going to cost. If your mom is in the United States, it's going to cost $1,760 if you're doing an adjustment of status. If you file before April 1st. If you file after that, the new fees go into place. Okay. So Kiski Taylor says, I'm due to file my citizenship this year. My daughter came here in December 2023. Can I file for her citizenship same time as I do? My U.S. citizen husband did her filing. So Kiski, there's a whole lot of information I don't have about this case. So I can't really answer. Your daughter came in 2023. How old is she? Her age determines whether she becomes a citizen when you become a citizen, or whether she has to file for herself as well. And if she does, she has to have gotten, if she has to file for her citizenship, not through derivation, then she has to have had it for 5 years, unless she got it through another means, which is what I mean by I need to get more information about that question so I can give it a fair answer. So Kobe Love says, I called USCIS on behalf of my kids to know what's going on with their applications. The kids are 14 and 11, but the representative that spoke to me said my name or my husband's name is not listed. I don't know what that's about. So maybe you can do an e-service inquiry, because sometimes the people that answer the phone don't really have the right answers. But I can't really help you with that because I don't know why they would tell you that. So, all right. So Delali says, hello, please, is widower supposed to go for interview? What could be the reason for the interview? So Delali, so what I understand from your question is that you filed an I-360 widower's petition, and of course they can interview you. Yes, they can. And when they interview you, it's the same thing. They want to make sure that your marriage to your deceased spouse was a bona fide marriage. That's number one. And they may have other questions that relate to whether you're admissible for the benefit you're seeking. But yes, it is very common to get interviewed when you file an I-360 widower's petition. So don't be nervous. It's not out of the ordinary. It is pretty common. Okay. So go prepared like you would if you had a marriage interview. You have to take all your evidence of bona fides with you and be ready to answer questions about your relationship. So Jay Denjehiam says, if I was deported for drug trafficking, how long before I can enter the US again? Jay, this depends, because drug trafficking, if it's more than 30 grams of marijuana, that's a tough one. All right. So, I don't want to give you an answer without knowing your case, but I can tell you anything more than 30 grams of marijuana, it's tough. All right. So Dawn says, give me your number, 973-993-1900. And let's see. So MZK says, please, how long does I-290B take? My case was denied because USCIS misplaced my medical. What are my options? So MZK, I really think you need to talk to an attorney, because sometimes we can do something called a service motion to see if they would allow you to submit your medical. With regards to I-290B, remember you have a certain window within which to file an appeal. So I really think you should talk to an attorney, because this case might be less complicated than you think. So, because an I-290B can take it can take a long time before they respond to you, and it can take a short time. I've had I-290Bs that were responded within 2 months. I've had I-290Bs that we got a response after 2 years. So I think you might want to talk to an attorney for real to see whether there are better options. Okay. Right. Joe Menz Jr. says, how can I file for my stepsister or my nephew? So Joe, my question is, well, your stepsister, you could file for her if the relationship was formed, the relationship, which is your parents got married. I don't know how the step relationship is, but if they were married before you or your sister turned 18, I'm assuming your sister is younger than you. With regards to your nephew, no, there's no you cannot petition your nephew as an immediate relative. But if your nephew qualifies for something else, such as SJIS, you might be able to be the guardian that files in family court so that they can green card through SJIS. All right, so I think, let's see. So Bula Belly says, I have a 10-year green card through family. I married my partner who's in the asylum process. Will that affect my citizenship application? I can't imagine why it would. Maybe I'm not understanding your question, but you have a 10-year green card, and you want to apply for naturalization. That naturalization looks for certain things, and being married to someone in asylum process is not a reason not to naturalize you. So, unless there's more to it. So T's Beautiful Braid says, can a green card holder file for their parents to come to the USA? No, only US citizens can file for their parents. And that's black letter law. So, all right. Black Beauty says, if I've been convicted of a crime and got my green card taken away, can I still apply for status? Black Beauty, there's so much information we're gonna need on that. So you might want to talk to a lawyer, because all crimes are not equal. So you might want to talk to an attorney about that. So Love Yule says, how long do I have to wait to file for my green card after marriage? There's no requirement to wait any amount of time, but like I say, it all depends. There are certain times when you want to wait a little, but there's no requirement that you should wait for any period of time. But I would say that if you came to the United States and got married right away and filed right away, you might have an issue with intent. So sometimes you might want to wait a little. So, but otherwise, there's nothing that says that you have to wait any amount of time to file. So good luck and congratulations on your wedding. And I think that's pretty much from Instagram. And I think that's it, guys. I know there's more questions, but I gotta run because I gotta go pick up my son from the bus stop. So, like I said, the fee increase is coming. So my suggestion to you guys is, if you need to file, you should do that now. And like I said, the good news is it wasn't so crazy like we were thinking based on the last year's proposed rules. So, thankful for that. Okay, take care, guys, and I will see you again next week. Have a great weekend.